Good afternoon. My name is Alina Shavtsova. I'm an immigration attorney from Brooklyn, New York. In today's legally speaking seminar, I would like to talk to you about what to do if you received a denial of your immigrant visa. It's very important because usually to get to the point when you can get to the interview for an immigrant visa, there was a big journey before that. Somebody had to file a petition, either the employer or maybe your family member, and usually the process would take at least a year or so to get to the point for the interview. You hoped for a better outcome, you collected a lot of documents, and now you got a denial. So what to do? So first of all, you need to find out the basis for the denial, precise basis for the denial. It's very, very important. Because some people call me and they say, well, my visa was denied. I say, why? And they say, I do not know. Well, you need to know. And how do you get that? The consulate should provide you a letter with a written basis for the denial. If you didn't receive this letter, you will have to request it from the consulate, right? Usually you can do it by email. Every consulate has an email specifically designated for inquiries in connection with immigrant visas. So you will receive your letter, the basis, very important. Then you will need to review it, preferably with a lawyer, with an attorney. Why? Because you're going to review the denial for factual or legal errors. Did the consul understand you correctly when he or she asked you questions, right? Did they apply the law correctly to you? If you believe that there were legal errors committed, you can actually, there is like a sort of an appeal process for that. You can write an inquiry, submit an inquiry through LegalNet to the visa office in DC. It's a body that supervises or gives opinions to gives opinions on different legal issues to help consulates to make correct decisions. And it's usually it's a legal brief, because what this visa office says that they do not review questions of facts, they review only questions of law. So let's say the law was misapplied to you. Let's say officer said that you were inadmissible when in fact you're not. Then it's a good route to take and to go to through this LegalNet route. Okay, so that's number one, what you can do. Let's say there was no factual legal error and consulate made the correct decision, but you can qualify for a waiver. Then you will need to submit that waiver. And of course, usually a person would know if he or she may face a legal problem after the interview, before the interview, and would contact an attorney and would be ready to address the issue as soon as it comes up, already having that waiver ready to be submitted. And the last situation is when there was no error and the law was applied correctly, facts were applied correctly, and you do not qualify for a waiver. That's what the letter says. The consulate found you to be inadmissible, let's say, on the basis of a controlled substance offense, and there is no waiver for that. What do you do? Well, then you will need to look into some other options, and perhaps your best option would be to get a non-immigrant visa, if you would qualify for it. Non-immigrant visa with a non-immigrant waiver, because sometimes there are no waivers for immigrant visas, but there are waivers for non-immigrant visas. And if you have family members in the United States, maybe previously you lived in the United States for a long time, you have other circumstances that warrant the grant of the waiver, you may want to consider that option. And you can read more about consulate practice and what you can do in different situations on our website, www.shavtsova.com. Thank you.